I see everyone. Looks like we've ironed out the issues with Zoom, and I don't know if we'll try this again, but maybe it won't be necessary. So based on our standing order, we have a couple topics that we generally cover, and we'll go over those. And if anything else comes up that we need to address, since we're all here together, we can go ahead and do that. So to kick it off, the first thing usually checking in on these case management hearings is the status of discovery. Obviously, I've received and reviewed Mr. Rafferty's motion on the issue. And then there was also an informal request to talk about some of the special grand jury testimony of the indicted co-defendants. I think it was specifically Ms. Hampton and Mr. Hall. So I want to start there, since that's a specific item that defense counsel has pointed to that they contend they should receive and should be entitled to. And there was some reference in the email about this may be a logistical issue because we just don't have a transcript yet, or I don't know whether there's a distinction here whether the state also doesn't think it's something that should be disclosed. So let me just throw the ball right over to you, Mr. Wade, if you want to let us know your thoughts on this particular issue.
Judge, those two particular transcripts have been requested in April. We still do not have them in our possession, but those are two of the transcripts that we do plan to turn over once we receive them.
And so I think Mr. Rafferty mentioned being willing to help you expedite them. Is that something you're willing to take him up on that offer?
Excuse me. What'd you say?
We can't.
I think he said he would pay for the expedited takedown.
So we made the inquiry, but that's not something that we could administratively make happen. I don't know if it's through the court reporting service or through some other collateral source that controls the service itself, but that's not something that we could make happen.
What about don't worry, Mr. Rafferty, we'll get to it. What about the idea? I think he'd be entitled at some point just to the recordings themselves, even if we can't put it in a transcript. Is there any hurdles to just turning over the audio files?
The only recording is the transcript. That there's no audio recording of the proceeding outside of the transcript itself.
So what I mean is, was the court reporter audio recording everything that she was taking down as well?
I'm not aware of an audio, Judge. The only thing that we could see was the court reporter operating. We hadn't been made aware that an audio recording is available. We could certainly make another effort and ask again, but we're not aware of any audio recordings.
Okay, so I think step one, just make a note of it for on the to-do list after we're done here today. Let's inquire with your court reporter whether audio recordings exist, and if not, we could maybe circumvent this entire transcription issue by turning over the audio recordings themselves. But I'm also not hearing the exact reason why an expedited transcript isn't something we can make happen, especially if the defense counsel's here offering to pay for it. And Mr. Rafferty, anything you want to?
Yeah, I mean, in communicating with the district attorney's office, they were happy to make the request. They did make the request. I told them I'd pay for it. And the response, it sounds like, was not that the district attorney's office could do anything about it. It was that somebody in the court staff, the court reporting service, was just not able to make that happen. Which to me, I think the court may well have the ability to sort of make that happen. Because the transcripts we're talking about, I've been very clear about what I anticipate will be in those transcripts, because at least as it relates to Misty Hampton, she's already given a sworn deposition where she said, number one, she authorized this, and number two, Ms. Powell had nothing to do with it. So unless she offered additional testimony different than that, it's clearly going to be Brady material. And Mr. Hall has given a recorded interview with somebody where he said essentially the same thing. So my suspicion is he said that. So these are two transcripts that in the eyes of Ms. Powell are vital to her defense. And as I said to the DA, and the DA was more than happy for me to do this, I'll pay for it to make it happen. So I would just see if the court might have the ability through its authority to go to the court reporting service and make that happen.
Yeah.
And Judge, I'm sorry, Judge,
Right.
we sort of echo that sentiment because the court reporter was being sort of I guess set up, if you will, by Judge McBurney prior to this court's assignment of the case. So I know that there's a direct connect to the court and the court reporting system. So maybe, I echo that sentiment. Maybe the court could intervene.
Sure. No, I think I've seen those orders before, and I'm happy to sign one because obviously we need to get this taken care of. So, Mr. Wade, if you could do this after checking on these issues with the court reporter again, if you could then let me know just by email who the court reporter is, and then if we still don't really have an answer or a timeline, we'll get an order entered. Expediting this to clear this up. So we'll keep a close eye on that one and hopefully have some direction, if not today, by Monday.
Thank you, Your Honor.
All right, so just kind of moving on with discovery. I know, Mr. Rafferty, you have that Brady motion that you'd filed yesterday, and I think that's something that we could schedule for a hearing if that's what you're asking for, and we could go through this in more detail. I don't think that was the intent to do here over Zoom, especially I think since it just came through the docket yesterday.
Yeah, yes, we filed 3 motions. I think that was not last night, the night before, and I would like oral argument on those motions. And so, whenever the court wants to schedule that, I will make myself available. I would appreciate a written response from the district attorney's office as to all 3 motions.
So I know we're resuming another jury trial on Monday that's supposed to go through Wednesday. So I think the first available time we'd have would be Thursday at 1:30, if that works for everyone's schedules.
Good morning, Your Honor. This is Scott Grubman. Thank you for your patience while I join.
Good morning, Mr. Grubman. We've just been talking about Mr. Rafferty's discovery issues, so we haven't really gotten anything involving
Thank you.
your client. Yeah.
Thursday at 1:30 is perfect for me. I don't know about the district attorney's office.
Okay. October 5th, Mr. Wade. How's that sound?
Sounds like an order to me, Judge, and we'll be there.
We're inquiring about schedules here.
Yes, sir.
So at a minimum, we can talk about discovery motions on that date. And Mr. Wade, if you can have a response by then, I think that could help narrow some of the issues before the hearing. So if you're going to have a written response, let's say that would be on 10/4 by close of business.
We can absolutely do that, Judge.
Okay, and then I just also want to make a comment. I did get the state's discovery notice filing, which I can't say I'd seen something like this before, but I do want to say that I'm not planning to file any kind of order or response. I'll just say that I expect the state to be adhering to the witness list rule. And if there are witnesses that are buried in discovery somewhere that don't make it on that list, we're going to have an issue and we're going to have to talk through it. And I don't see how this incorporation is going to solve those. And just placing parties on notice that somewhere within these mountains of discovery, there may be other names. I don't think that's the intent of the uniform rules or the witness list statute. So you can notice what you'd like, but we're going to have a fresh analysis if there's a witness that doesn't make it on the 10-day list. And in terms of the issues of good faith, I may even suggest if your reaction to this is just to put 800 witnesses on there, and so any witness that ever came up in discovery makes it onto the list, again, I think that's going to go against what we would expect from a witness list. So I may even suggest that we incorporate some of the civil standards where you have a will call section of your witness list and a may call, just to try and narrow the focus. I think the idea that just putting people on notice that anything in the file could be called, I don't think that's going to satisfy the burden. So I'll just make that observation. If there's anything you want to add, we can feel free to do so, but otherwise we'll take it up at the point when there's a witness who's not on the list who's called.
Yes, Judge, we understand, and that's not the intent of the state at all, to bypass any of the witness list requirements. Really just a notice to be made part of the record in case there's, happens to be one person or two people here or there that for whatever reason may not make it onto the witness list. We don't anticipate that would happen, but just kind of covering our bases filing. It's one of the standard filings that we file in the majority of our major crimes division cases. But again, no intent to skirt any of the requirements at all.
All right, anything else? Anyone want to add a comment or be heard on that? There's really no reason, since we're not really deciding anything, but I thought I would just express my initial reaction to that.
Well, Your Honor, what I would state is, if the government's intention is to, as the court noted, tell us about all the different folks in the discovery who might get called, that opens the door then to the production of all the special purpose grand jury transcripts, because all of those folks are potentially then witnesses, because all of that is somewhere buried in all this discovery. And so with the notice, I think the government has now also put itself in a position where it has to produce all of the special purpose grand jury transcripts, not just the ones that they've produced thus far.
Mr. Wooten, you want to have any reactions or comments to that?
Judge, we'd request a little bit of time to look into any potential issues that might affect our position on that. Our understanding of the court's instruction as far as when we need to turn those transcripts over is very clear. It's just there's so many of the transcripts that we would need a little bit of time before we can actually make a position right now.
Respectfully, Your Honor, I think the court has said that the witnesses that will testify are the ones for which they are required to turn over the grand jury transcripts. Through the notice that they filed, they've indicated that all those people could be witnesses. Therefore, we're entitled to all of them.
It's certainly something I think, Mr. Wooten, you opened yourself up to by this kind of broad sweeping incorporation. But for now, I think we can wait and see what your witness list looks like. And as we mentioned before, I don't think we're going to be able to just say because a transcript hasn't been prepared that it doesn't get turned over, because the statements of witnesses statute specifically talks about recordings. And so potentially there's the issue of a recording exists. Maybe it's in the possession of the court reporter, but it's something that we would be able to get our hands on. So we'll have to keep our eye on that. And I think we flagged the issue going forward. Anything else on discovery you think we need to just touch on here in this?
And we can discuss this next week during the hearing, Your Honor. But to your point, Brady material is in the possession of the government in whatever form it appears. And if there are transcripts or testimony that was taken before the special purpose grand jury that has not yet been transcribed, that does not relieve the government of their obligations as it relates to discovery and Brady. If there's an oral transcript of testimony that contained Brady material, the government is obligated to disclose it to us. So I would just ask that that be included, and I'll plan on raising it next week during our hearing.
All right, I think we've made that clear. Anything else? All right, let's move on to the motions we've got filed. We've just entered an order on the Mr. Chesbro's search warrant and immunity challenge. So those should be hitting the docket soon. We obviously have a number of others that we need to get through. We're still working our way through them to see which ones we think require a hearing of some kind. So far, it doesn't seem like any of them would require an evidentiary hearing. It would all simply be oral argument. And the first thing I wanted to ask to both defense counsel, or all the defense counsel rather, now that the state has filed some responses, was there any desire to file replies to any of their responses?
Your Honor, as to the RICO issue, we wanted to present a witness, so I'm not kind of clear. Are you saying there's going to be no argument on the two RICO motions that we filed, or you will give us argument? We'd like to present at least one witness for the RICO issue.
Which motion would this one be? Because there's a couple of RICO motions.
The continuity one won't need a witness, but the first one with regards to the motivation of pecuniary interest as written in the 1614-2 and the legislative intent, I need to call a witness for that one.
And what kind of witness would this be? Is this like a legal opinion you're trying to submit, or?
All the Senator Clay, who wrote the statute, the amendment in 1997 that the government's going to be relying on.
Yeah.
Legislative intent as far as that goes, and why they wrote 1614-2 specifically as to what RICO is supposed to cover, and whether it's, then we'll argue whether it's gone past those parameters, because there is no case law that has a RICO case that doesn't involve some type of financial aspect or violence. So you can Westlaw RICO right now, and hundreds of cases will come up. They're all check fraud, bank fraud.
No, I understand. I understand your argument, and we were going to dig into that. It's just it seems a bit novel to me on a demur to be hearing live testimony, and so that'll be something we have to think through here. I think it's also something you could potentially submit simply as an affidavit. I don't know if we need a full-blown hearing on a demur.
I could do the affidavit. I just didn't know if the government wanted to cross-examine him. And the reason is we're in uncharted territory with this RICO issue, and so we. Unlike most 99% of our statutes, you don't actually have a code section within a code section saying this is why we're doing this statute. So the man that wrote it, Judge William Ray, is the federal judge. Obviously, he's not coming, but Senator Clay was the other one that co-authored it with him, and he agreed to come and answer those questions as far as legislative intent, what the point of RICO was at the time.
No, it's an interesting argument. He wasn't the only one that voted on it. So if you're also going to bring the governor that signed it and the 50 other senators that voted on it, then even then, I think we're getting into areas that our Supreme Court has said legislative intent is fairly irrelevant. We're supposed to look at the plain meaning of the statute. So,
right, but my point is this isn't necessarily intent, Your Honor, because it's actually written in the statute as a code section. This isn't the notes at the end of the Westlaw, and so I thought.
Right. So we read the statute and we go from there. I think even if you bring in the person who wrote every word of it, it seems to me the initial reaction is that's pretty much completely irrelevant, but we'll see. Let me keep looking at that. I'll note that you want a live testimony on the demur for the RICO. Were there others that you said you contend should be an evidentiary hearing?
No, just the RICO is going to be the evidentiary hearing. The others are just an understanding of what the ECA means. But I'd like to have oral argument because it's not quite as simple as some of the responses from the government.
Okay.
Especially as it comes to some of the demurs we filed at the substantive counts, Your Honor. Because if the ECA authorizes certain things, then even if says we listed the elements in their brief, they don't cite the Jackson case from the Georgia Supreme Court from 2018 that says you got to do a lot more than just cite the elements and those things. And so I'd like to be able to discuss that as well. They're not going to be long briefs, but I'd like to be able to perfect the record.
When you talk about briefs, does that mean you'd like to file a reply brief to some of these?
Like to be heard instead of just bearing you with paper. I think in 10 minutes on each side, I can go over what the Jackson case is, which wasn't cited by the state as to what is required for a demur. It's not you can say, hey, we listed the elements and too darn bad. That's not how it works. And so I just want to be able to sort of flesh that out over a very short argument if we're going to do multiple motions in one day. And I think it just helps you perfect the record versus filing paper, not filing paper, and then you're stuck reading a lot of this stuff because.
Well, no, I think I don't mind reading at all. That kind of comes with the territory. And in fact, I think sometimes that can be more helpful instead of me frantically writing down all the sites that you're throwing at me. So I'd appreciate a written response, especially if it's just kind of a overarching kind of umbrella to why the demurs maybe aren't as straightforward as the state is saying. So how much time do you think you'd need?
I can try to get it done. It's just we're trying to get the jury questionnaire together. We've got 178 witnesses on the list. I think your standing order says don't do a phone book method. Give us the real witnesses that you're going to call. So at some point, I'm spinning my wheels trying to track down a lot of people. So I'm just asking if I could have 10 minutes to argue it versus writing. Just we're down to 3 weeks before we theoretically start jury selection. And we've got to review the questionnaires once they get filled out over a weekend, like 450 of them. I mean, we've got a tall task with what's happening here. So
well, you're not going to get too much sympathy from me, Mr. Aurora. I mean, this is a timeline that you signed up for, and I'm happy to give it to you, and we'll make it happen. But
Your Honor, if you want responses, can we have, let's say today is Friday. I mean, can we have a week?
Yeah, that's fine. The next hearing date I had flagged was potentially October 9th. I believe that's a Monday. I'm not mistaken. I have to double check the calendar again. But we could flag October 9th for an argument date for some more of these substantive demurs. Especially as it relates to the RICO counts.
Please don't get me wrong. I'm not disagreeing with my co-counsel. I totally agree that we would like oral argument, but the courts seems to be making clear they want a written response. So I'm just trying to figure out as much time as we can get. So if we can have a week, I think we can make it happen. But if, as my co-counsel said, if you might just at least take under advisement the possibility of giving us some time in the courtroom, we'd certainly appreciate it.
Well, it's just the reality is that you know, it's a written response, especially if you're saying this is more than what the state has responded, then it's going to give me, it might make the oral hearing actually more productive if I can respond and ask questions. So I'd rather make all of our time more productive. All right, so let's flag 10-9 as a motions date for some of these RICO demurs. And if you double check what calendar date that is.
That's the 6th, October 6th. Friday.
Okay, it's a Friday. Or no, October 9th looks like a Monday to me.
I guess what Mr. Grubman was suggesting, replies.
All right, replies by the 6th.
Friday.
Okay. Yeah, fair enough. Okay, so if you've got responses to the RICO demurs, I would say 10-6 would be the time to get them in. And again, we'll tentatively set a hearing, oral hearing on those on 10-9. And similarly, I think the motions that both parties joined on the Supremacy Clause and First Amendment and your reply briefs desired there.
To the extent that we would file a reply, Your Honor, we'll have those as well by October 6th.
All right.
Will Your Honor give us oral argument on those, or is it just your saying?
Oh, I'd like to see what the responses say. So I'm still going to have other motion state that we can flag. 10-16, 10-17, 10-18. I think that's going to be, I would just block all three of those days off for kind of our catch-all arguments and last minute motions and things that are coming up.
Okay.
So I think that's probably the cleanest way to do it. So any responses that the defense wants to file in writing, those are all going to be due by 10-6, close of business. And if you could provide us courtesy copies as well.
Yes, Your Honor.
And all right. And we'll just have to, we'll go through them and we'll keep you updated on which ones we think. I mean, some of these, again, as we dig into them, may decide that the issues are clear enough. I mean, that certainly was my reaction to the search warrant immunity motion. Some of these may be the same way, and we'll keep you updated as we move along. Anything else just in general in the motions practice that's coming up?
Your Honor, I had a question about the earlier motions filed regarding the grand jury.
Yes, sir.
And status of that.
So do anticipate that some of those questions are going to be appropriate. Now we're just logistically trying to figure out how we begin the process of reaching out to the grand jurors.
Okay, thank you.
And we'll follow up. We'll obviously tell you and email you which questions we're going to be able to go forward with and how logistically we're gonna do that. So still on our radar, still working through it.
Thank you.
Anything else?
Not on motions, sir.
Okay. So the next thing, just generally in the case management scheduling order, is disposition without a trial. So all I would generally ask here is if the state is planning to convey any offers in this case. I want to ask, and I don't need to know the specifics or the substance of them. I would note that before we kick off a trial, we'll make that a part of the record in terms of a history of offers and that they've been rejected or accepted. But I do try to flag that at case management just to ask the state at this phase that if an offer is going to be made, that it be conveyed at this point.
Judge, we understand. We have not made an offer. Most of our communication with defense counsel has been surrounding the motions and discovery issues, but we have not at this point made an offer.
Is the state in a position to be able to make one in the near future?
Judge, I believe that we can. We'll sit down and kind of put some things together and we'll reach out to defense counsel individually to extend an offer.
All right. Thank you, Mr. Wade. I think that's really all it's more of a check mark on the to-do list here, unless anyone wants to add anything else. But generally what I'm trying to avoid there is we show up for jury selection and all of a sudden there's a lot of back and forth and flurrying of needing to get approvals and that sort of thing. So I'd like to iron that out so we can start fresh when we start talking to jurors. Okay, moving on. I'll just flag that again in the case management to-do list, we make a note of expert testimony. I imagine there's going to be a lot of it here. We say in the case management order that it's supposed to be turned over 14 days before it's used or before the hearing. I think in this case, it would be more appropriate just to add that and make it a part of the witness list. So 10 days in advance of trial for the state. And that includes not just the name, but CVs and a meaningful summary of what the testimony would be, just so we're all on the same page of who's going to be tendered as an expert and generally what topics are going to be covered. Is that fairly straightforward? Anyone want to add anything on that?
Is there a date, Your Honor, that the court has in mind for defense experts?
Again, I think we'd stick to the witness statement statute. So if the state's witness list is due 10 days before trial, the defense's is due 5 days.
Okay, thank you.
Understood, Judge. Thank you.
All right, good deal. Okay, and then I think the last thing I had before I again turn it over to you all to see if there's anything else would be just starting to again talk through the logistical issues of how, when we kick this thing off, how voir dire is going to go. As y'all probably saw on the docket, we're actually officially kicking it off on a Friday on October 20th. And that was simply because to get that many jurors in a room, Friday is the only way we can do it rather than a Monday, because this would be the only case having jurors come in that day. And as I might have mentioned at the last hearing, the idea on Friday would simply be the jury questionnaire day, where we would start off all going up to the 7th floor where the jury convocation room is, and everyone would be seated there. So I'd encourage you all to take a look at that area before we start the trial. There is kind of it's almost shaped like an L. So there will be a section of jurors kind of around the corner almost, but there would be a live feed where they can see us and everyone would be free to get up and wander around and, you know, be able to observe whatever they need to do. But the idea would be we start off, it's kind of the standard introductions. The idea would be we summarize the indictment. We're not planning to read it in its entirety. I think the case law supports that. So Mr. Wade, one of the things to throw on the to-do list would be, I would ask you to write out exactly in a paragraph or two how you're planning to summarize this indictment. And then that's something we can be passing back and forth to see if there are objections to the way it's characterized and make sure that's not something we're just winging the day of. And then from there, you know, we'd get the standard preliminary remarks, pass out the questionnaires, and for the next couple hours, we can sit there and watch everyone fill them out. And that would be it for the day. And we would collect those and we'd immediately start scanning them in. And what we're working on is trying to get everyone access to a shared drive. So as they're scanned in, you then have access to them. And we would try to make those, we'd have those go in order of juror numbers. So you're not going to get all 400 scanned in the first day, but at a minimum, I would think you'd have the first 25 so that leading up to day one of individual voir dire, you've at least got that day's worth of juror questionnaires that you can prepare for. And we would just, on a rolling basis, keep adding those questionnaires for you to access. And moving on to individual questioning, that would be over in the courtroom here in 5A. And the plan right now is, again, this all may change depending on how things go and logistically how we're able to use our time. But we start at 9 a.m. with a panel of 14, bringing them in individually one by one. And I'll probably go into hardships based on what's on their questionnaire and then turn it over to the parties. And when we turn it over to you, we're going to incorporate some of the federal model here. And the plan is that we're going to have some clocks installed on the wall, some digital clocks. Each party is going to have an hour for that panel. And however you want to use that hour is completely up to you. But once your hour is over, your questions for that panel are done. And we'll rotate which party starts off the questioning for each individual juror, just so one particular party isn't always having to go first. So that's and then we would do strikes for cause or favor after each panel of 14. And we do one panel of 14 in the morning. If we're able to get to that and through it by lunch, another panel of 14 is waiting for us in the afternoon. And we repeat until we see how many we're able to qualify and what our burn rate is. So that's the plan of attack right now, open to input from any party. Mr. Rafferty.
Yes, when you say an hour, is that an hour to be shared between counsel for Mr. Chesborough and counsel for Ms. Powell?
No, each defense counsel would get their own hour.
Okay, thank you.
Your Honor, one other thing, I haven't filed this yet, but would you consider providing extra strikes? Because theoretically, we have to share the 9 with Ms. Powell. I hadn't done that, but I didn't know if you already thought into it as far as giving us a few extra strikes. Just
you can file the motion, and I don't think that's something I'm going to rule on before jury selection, though. That's something I'll take up when we're in the thick of it and we see how we're doing. The initial reaction would be, like I said, going off the severance motion, I don't think there are antagonistic defenses here, and it sounds like that might be something y'all are able to collaborate on and share. But I'd be willing to hear your arguments when we get into it. So just to preserve the issue, feel free to file a motion.
all right, and you said after the 14, we're just doing challenges for cause at that point, and then we go to the next thing until we get whatever group. And
That's right. Depending on the timing, if we're not through with that first panel of 14 until 1 o'clock, we're just going to have to bring in the next panel, and we'll save all of the challenges at the end of the day. So ideally, we do them in between when it's fresh, but we're just going to have to see how things go.
How many alternates is Your Honor planning on having?
I think we'd be shooting for around 6.
And are you, in your opening remarks, going to be saying this trial is going to be 6 months or whatever, since you're going to deal with the hardship questions? Because I'm sure there's going to be a ton of those.
Yeah, no, it's a good question. I'll distribute the script that I'm planning to read from for those introductory remarks, and so we can all kind of work through what we think is accurate there. But my plan was to say 3 to 5 and take it from there. And I would be telling everyone, since there's a lot of travel over Thanksgiving and the holidays, we'd likely be taking off the week of Thanksgiving. We'd likely be taking off the last 2 weeks of December. And we'd also probably be doing Fridays off. So it'd be full days, at least 9 to 5, Monday through Thursday, and then accommodating those holiday periods. And I think that's still going to give us a lot of productive time each week to get into everything. But the plan, to answer your original question, was to inform that it'd be 3 to 5 months. And if there's any other thoughts there, though, happy to hear them.
One other question: if Your Honor is going to have Thanksgiving that Monday, Friday off, and then the 2 weeks before Christmas, it impacts some of the other cases I've got. So could Your Honor issue something saying like from the 17th of December until the 1st, I guess, or the 31st is 2 weeks is off, because I just don't want any conflict issues with some of the other courts, so I know I can cover something during that time frame that I've already got.
I'm not tracking. So you're worried you're going to get called in on another case, like during those 2 weeks of December?
There's a few other things I need to deal with that aren't super serious. I would like to deal with them. So if you're saying that we will be taking the last 2 weeks of December off, I'd like to sort of iron that down firmly now so I can plan for that, because I'd like to be able to handle that person's case so they're not just languishing, where they are. So if we've got the 2 weeks off, I can take care of some business over that break. And so
Okay.
saying absolutely we'll do that so I can plan it, or if you're saying you're thinking about it.
So since that's still I think I'm planning to tell the jurors that. So let me make sure that we've ironed this down and this is the way we want to go. But if you need something in writing, we can work through that. We can talk about it. But I don't see a need to fit in a day or two here. I anticipate we're going to lose a lot of jurors if we try to work through those 2 weeks. So I don't really see why getting a day or two in there I don't see that being worthwhile.
I don't need it in writing. If you're just saying we'll have the last 2 weeks off, I can go ahead and file conflicts on something I want to be able to resolve starting on the 18th.
Sure. Any input from the state on this? Just kind of some of these logistical voir dire issues we've laid out.
Judge, I don't think we have any objection to what the court's laid out. That sounds good to us.
Okay, Mr. Rafferty, any thoughts on the process other than you know we talked about the hour per party?
No, Your Honor. The only other question I had is, you mentioned some kind of summary of the case that you're going to read on Friday, the 20th. In some cases in federal court, the judges will entertain not just a summary of the indictment, but a summary of the defendant's contentions. Would the court consider at least looking at the defendant's contentions about this so that the jury or veneer is not just going to be hearing what the government has obtained in the form of an indictment, but what the defendants say in response?
Certainly would consider it. Just again, the idea here is not to. I would think you could handle that in a sentence or two, and if that's what it is, then
Sure.
I'm not seeing why that would cause any issues. If it's simply Ms. Powell contends that she had nothing to do with this, and if she did, she had authorization. That would be more like, I think, the civil standard, how they kick it off. But again, the idea is that we're not summarizing our entire case. The government can say this is a RICO case. These are all the people that are charged. These are the two specific people that are here today, and here's what they've been charged with. And I'll certainly consider if you want to add on a sentence or two at the end saying the defense, however, says this.
Thank you.
But we can take that as we get closer and work on that script. Mr. Wade, I think you want to weigh in here.
Judge, our understanding of what the court was describing was simply just kind of an outline of what the indictment says, not so much as the state putting on its actual theory of the allegations. And I think that counsel's recommendation to the court is essentially him wanting to put his defense forward in this summation, if you will. And I just think that probably goes beyond the court's request. We certainly would have an objection to that happening.
Yeah, no, that's a fair point, Mr. Wade. Let's see. I'll think on it. Let me double check the case law on this and the pattern instructions of what the intent is, why we do this anyway at the front end. I think generally we're doing it to let the jurors just know, hey, what is this case and what's it about, so that we can qualify them. But you raise a good point that we shouldn't really be getting into the issues per se necessarily. So it's a good issue to flag, and we'll keep working on it as we move forward to the 20th. That, I think, is everything I had to talk about for voir dire, unless there are any other things that y'all can think of.
Your Honor, you gave us dates for the motions, but are we going to get together on the questionnaires to sort of iron out what the questions will be? I'm sure that'll take several hours to sort of sit down after we share each side's.
Yeah, absolutely. That's why I think we should. I think we had, like I said, I would just block out the 16th, 17th, and 18th. And on one of those dates, we'll meet and we'll talk about questionnaires. And based on this morning's experience, I can't promise it'll be over Zoom, but we will find the time. And again, any kind of holdover motions that we think still need a hearing, those will be the dates.
Judge, there is a matter that the state would like the court to address.
Yes, sir.
If it's okay. There are 4 remaining defendants that had not.
I think there's 6 actually. I think there's 6. And today was the day I was planning to check in on them.
Okay, so you know where I was going.
Oh yeah. Anything else?
The other thing, Your Honor, I think some of the lawyers, I saw an email from Mr. Samuel this morning. I guess there's a couple of these motions that apply to everybody. I didn't know what the court's position would be, because I think you made a good point saying if you rule this way with Mr. Chesbrough and Powell, it's going to be hard to sort of reverse it for the others. Would that be something we need to plan for, that other lawyers that have authored motions that are global for everybody?
Understood. Right now, because we have to stay, I think, focused and getting this case ready, handling the logistics of getting everyone here, handling the arguments. I mean, the motions that you adopted, there are certain aspects of them that I think would apply to your client and to Ms. Powell. but wouldn't be as applicable to everyone. So I think that there's going to be a way that, and I think we're just forced to, based on where we are. The plan is just to decide those motions as they pertain to Mr. Chesbro and as they pertain to Mr. Powell. It wouldn't foreclose their ability to argue them later and any of the potential legal arguments that affect them differently. So no, the plan is we're just going to stay, keep our circle to just who's here now until we get this trial taken care of.
Your Honor, I had a few other housekeeping issues. I don't know if there are others.
Yes, sir. This is the time.
This is the time. Okay. Initially, what I wanted to ask about is jury instructions. My experience typically is that's something that, my experience is it's submitted before, at least a draft of the jury instructions are circulated with the parties before the trial commences, before opening statements. So we have a sense of what the law is. And, in federal court, jury instructions are pretty well patterned out. You know what to expect. My cursory review of the state instructions, there's a lot of instructions that, there aren't a lot of instructions for. And so is the court willing to entertain requiring the parties to submit jury instructions maybe by the 23rd of October? We'll be in the midst of jury selection, but we'll at least have a sense before we actually get to opening statements of what the law the parties contend is at issue here.
Yeah, that's an interesting point. Certainly it would be the most efficient way to narrow our focus, but I don't think that's our practice here in Georgia. In fact, I don't have the uniform rules in front of me, but I think the requirement there is simply that they're submitted in writing, and then we have a charge conference. And it's a lot of times we can't actually figure out what instructions are appropriate until we know what the facts are that came out of the trial. So I certainly understand your motivation. I certainly love the appeal to efficiency. But it's a bit of an uncharted request. I'm curious if the state has heard this or had a chance to chew on it, on the idea.
Judge, we've had some discussions about this, and to the court's point, I think some of the charges we might be able to submit to the court ahead of time. But again, as the court pointed out, many of them will depend on what the evidence is. So we would defer to what the court would like to do. We're ready to do whatever the court instructs us to do. But again, until we hear what the evidence is, I don't know that we can really do a full charge conference.
And Your Honor, I understand that, while it may be uncharted, I understand in state court and federal court across the country, trials happen and jury instructions are typically submitted. And there's, for example, there's an instruction if the defendant testifies. There's an instruction if the defendant doesn't testify. But there are certain instructions here which I think would be valuable to at least see what the parties' views are, the elements of RICO, what the statute says, what's required to prove somebody's participation in a RICO conspiracy. All of these things, I think, they're not written in stone. And I get that at the end of the trial, the judge is going to have a charge conference and will select what the appropriate instruction is. But I think there's value to everyone to get their perspective on what the law is going into the trial. It doesn't marry anybody to it, but I think it will be helpful to everyone.
Hey, Mr. Rafferty, like I said, I think it's a good point, and we do have so much on our plate right now. Again, I don't think I can hold or require any party to submit them. But if we want to get in there and make some preliminary findings saying if the evidence is this, then this charge would likely come in. I mean, we can have that discussion. I don't think I can issue, like I said, a definitive ruling saying this will be the charge that happens. But if we want to have some of those discussions, I'm game, because it does, I think, in the grand run, benefit everyone to know where the focus and where the issues lie. So I'm open to it, but I think it's going to have to, it's in terms of the list of priorities, it's going to fall towards the bottom simply because we may not have time.
Understood. It was just a thought. In terms of the courtroom, has Your Honor decided, are we going to be trying the case in 5A? Is there another courtroom?
Right now, because there's been some other, I think, speedies that have been filed that have more defendants than this one. The intention is we'll be in 5A, that it can hold us if we need to reserve certain rows for extra attorneys or legal assistants or investigators, let us know if we just need to block off the whole first row or the legal teams. But other than that, we also have we have a side room that we could devote to defense counsel's use. Same for the state. We do have some smaller rooms that we could unlock and give you exclusive access to for storing things and the like. But right now the plan is 5A.
Okay.
For
Is there,
voir dire and the evidence.
again, I can't recall how big the room is, but is there a sufficient space in that courtroom to have a second table for the defense side? Because I know we haven't had the defendants in the courtroom with us. It's been pretty
Right.
quiet sitting there, just the lawyers. Will there be a second table we can have so that for Ms. Powell, we'll have a table and Mr. Chesborough will have a table?
Let me work on that. I think there should be room to fit one, maybe do like an L shape. And I'll see if we've got one that we can procure.
Thank you. You mentioned conference rooms. That was another request that I had is, obviously we want to be as efficient as we can with our time, lunch breaks, things like that. If we're able to have a room that the defendants could use to store stuff, as you said, have our lunch, have some waters, things like that, we can use that and be back in the courtroom in a timely manner so that we never lose a minute of time for the jury or the court.
We have that, and we'll show it to you at our next motions hearing so you can explore that space. It's nothing too extravagant or luxurious, but it has a door and the door works.
Perfect.
And that's all I can promise you.
Perfect. And then just some other things I just asked the court to consider. There's going to be a lot of witnesses in this case, and the government has 178 or whatever it is. My experience in a lot of trials, big trials like this, has been the government has been asked to disclose the witnesses for the next day in the morning. So at least we know who to expect the next day, recognizing that things can change. I don't think, there's a lot of value in trial by ambush. If the government knows who they're going to call the next day, I don't see why they couldn't at least give us a heads up so that we know what to expect. And I just asked the court to consider that. It's most of the big federal trials I've had, the judge typically requires the government to do that because it tends to move the case along. So I just would ask the court to consider that. I don't know what the timetable is for the government's disclosure requirements as it relates to exhibits, but same sort of thing, because I think that, once we get their exhibits, I think there may be an ability to reach some stipulations on the admissibility of those records and documents. If we can do that, I think that's also going to move this case along. So I don't know if there's a schedule in place for when the government will be disclosing all of its exhibits, but I think there would be value if we can get them in advance of the 23rd so that we can decide if there are things that, we are going to stipulate to, so that we don't need to have custodians of record or anything else coming in. And we can likewise try and get some exhibits to the government to see if we can reach similar kinds of stipulations.
Understood, Mr. Rafferty. Mr. Wade, just on the idea of giving previews of what the next day looks like, obviously it wouldn't be binding and things change and things come up, but just as a professional courtesy, what do you think of that?
Judge, with a backdrop of it not being binding and things do change, the state is not trying to make any attempt to do this trial by ambush thing. We're disclosing everything that we have. We're giving over discovery. We're giving over the witness list. We don't have a problem sharing with defense counsel the witnesses that we plan to call the next day if we can pin it down like that.
All right, fantastic. And then in terms of an exhibit list, that is not something that's generally required in advance like a witness list is. Certainly, I always appreciate having one so I can be following along and checking off what's been admitted and what has not been. So for now, let's just say I'll leave it to the parties to see what they can work out amongst themselves. And again, the idea is I think it serves all of us to be able to proceed efficiently and to focus on the issues at hand and not be worried about authentication or simply what the number is of this or that and slowing us down. So, Mr. Wade, if you want to add anything about an exhibit list, I certainly think it's a good sentiment, but I don't feel the need to set another deadline for something in so short a time period that's not required by statute.
Nothing to add, Judge. We agree with the court.
All right.
And then the only last issue I asked is with respect to exhibits, is the government going to be producing those in digital form, or are they going to be just paper copies?
So the rule around the courthouse here, and it's sometimes not always enforced as strictly as it should be, but there is supposed to be a digital copy for the court reporter, for the record, in terms of what's actually used to hand to a witness or whatnot. I think, we usually will see those in all sorts of forms, but I'll just note that there is supposed to be a digital copy for the court reporter throughout of every exhibit that's tendered. And Mr. Wade.
No, Judge, I'm told that everything that we have is digital anyway, so no problem.
Judge, do we have technology for that, or some judges are making us do a screen share on a Zoom, which is incredibly complicated and fraught with error?
You don't think our experience today has enamored you with our Zoom capabilities? No, that is the setup. Every courtroom has the same setup, and we've had enough trials in the courtroom where once maybe on one of these motions days, we just let you play around with the equipment to gain some confidence with it. But so far in our trials, more or less, it's worked. And it's got the ability to zoom and mark the screen and do whatever you need to do with the exhibits. But throughout the trial, we're all on a collective Zoom call. And that, yes, we share our screens to be able to share exhibits. Frankly, I don't think there's any other way now that any of our courtrooms are operating but through that.
Okay, well, I'll miss the Elmo machine then.
That's right. No, the Elmo machine is still there. I don't even think it's hooked up to the Zoom capabilities. So we've moved on, for better or worse.
Judge, if we could just go back briefly before we wrap up here, the court reporter issue, was it the court's intention to convey that the state should just share the contact information with the court and then you'll start to push the effort, or how do we?
Well, I was hoping you could give me a more definitive answer from the court reporter of their position today. So just to be able to contact them today and say, if we requested an expedited transcript, could you make that happen? And when? And if not, can you give me the recording? And based on her response, then get back to us and I'll enter any appropriate order that we have to do.
Yes, sir. Yes, sir.
Okay. And then in terms of if we need to recap here in terms of the to-do list, on 10/5 in the afternoon, we'll at a minimum be arguing the discovery motion of Mr. Rafferty. If there are other motions that come up that I think we can add to that, I'll take a look and I'd be happy to hear your thoughts on it. 10/9 or 10/6 would be due date for reply briefs, if any, from the defendants. And then 10/9 would be a date for us to argue some of the demurs related to the RICO counts. We've also got some other dates that we can hold to see what comes up. October 10th and October 11th, those are afternoons we can use as things come up, just FYI. But the 16th, 17th, and 18th are also going to be our dates to be scheduling everything we need to schedule, including a questionnaire discussion, because I think the questionnaires would have been submitted by then. Are y'all still planning to do a consolidated one?
On the defense side, we are.
Okay. And let's see. Again, going over a recap. I think we've covered a lot of ground. Okay, anything else from the state?
Judge, with regards to the presence of the clients, can you still do Zooms and still live out of state?
Yeah, for all the motion hearings, if you've got express permission to waive your client's present, we'll keep doing that.
Nothing else from the state, Judge. Thank you.
Okay, thank you, Mr. Wade. Anything else on behalf of Mr. Chesbrough?
Nothing, Your Honor.
Okay. And Ms.
I'm sorry, I may have cut Mr. Aurora off. I apologize.
Sure.
We're in different places.
As to October 20th, and we're just passing out the forms and doing the preliminaries, do you want the clients here? Could they just come on the 23rd when we actually start doing substantive questioning of the jurors?
Well, October 20th, the 20th would be when we're introducing all the parties, all the attorneys. And that's when all 450 are there, and counsel, identify yourself. So that would probably be a good chance for your clients to be there, but
No, I didn't realize that. I thought we were just fine. We'll have them there. And then is it 450 or a total of 900 that you're filing?
it's in stages. So it would be 450. I forgot to cover this. 450 on 10/20. We're going to see how the week goes, what the burn rate is, how many we get through, how many we qualify. And then if we need to do another 450 with questionnaires all over again, that's the next Friday. So if we're on track from that Monday through Thursday of qualifying, 5 or 6 a day, which is really all we need to make the deadline, we won't need that Friday, those extra 450. We'll just keep going with that original batch.
Judge, we did have one other thing, forgot to mention. We had filed the notice of potential conflicts a week or two ago.
Sure.
To ask the court how it planned to address that.
So I think Mr. Grubman had filed a response. And Mr. Grubman, I think you'd indicated that there's some documentation you'd be willing to provide the court. If you could email that.
Yeah, and Your Honor, I'm sorry, I really, in my not that many years of experience, usually a prosecutor will give the very basic professional courtesy of reaching out to ask. Mr. Wade decided that that was not something the state wanted to do in this case, which is his prerogative. But yes, I have waivers that I believe are going to satisfy the court. I would argue they are privileged. And so I would ask if the court would like, I will submit them in camera for the court's consideration. I asked Mr. Wade and his team to please pick up the phone next time and call, because I don't think we have to waste the court's time on every little thing. And we certainly will try to return that basic professional courtesy that usually lawyers in the state of Georgia give to one another.
All right, Mr. Grubman. So if you would email those over in camera, and I will, after reviewing those, if I think that if there aren't any issues remaining, I'll file a very short order noting as much without the substance. And I think that would resolve that issue. So, okay, other than that, Mr. Wade or Mr. Wooten?
I think that's all, Judge.
Okay, if you say so, we'll see by the time we get back around. Mr. Aurora.
One silly question. I know.
Oh, God. What you got?
In regards, since we're doing RICO on the 9th, are you saying I can call my witness or not? Or are you just going to wait till we have the reply briefs just so I can have the witness available? Or should I just have him on standby, I guess, since he's in Marietta?
Yeah, let me take it under advisement. My goal is not to waste time, because we don't have a lot of it. And if this is just going to be a dead end for you, then I would say submit the affidavit to perfect the record. But we, in terms of live testimony, if it's not going to have any impact on the analysis, then I wouldn't be looking to do a hearing.
And I'm sorry, Judge, begging the court's indulgence. We couldn't hear Mr. Aurora. Who is this? Who's the witness?
Senator Clay is one of the
Clay.
authors.
Senator Clay?
So, Mr. Aurora, I'll get back to you on that. And if nothing else, what we could also do is on that particular, I think you said it was the legislative intent, we could have that hearing later after I've been able to read your response and digest it. And we could have the other demurs on 10-9, and we could have that one and on that issue at one of the later dates, like 10-10, 10-11, 10-16, something like that. I mean, obviously, just based on where we are and what's going on, a lot of this is going to have to be touch and go and playing it by ear. All right, I'm not going back to the state. I'm done with Mr. Chesbro and Mr. Rafferty.
One question, Your Honor. You mentioned there are 5 or 6 other folks that I guess have not indicated one way or the other.
That's right.
All of these dates are obviously with the best of intentions. If somebody else decides that they want to join us on the 23rd, are we going to have to, and I think you mentioned that people have to make a decision today. Is it possible that we may have another one of these conferences early next week if somebody else decides to opt in?
I think that's quite likely. So I will be checking in with everyone today. And based on the feedback and the response we get, if it dramatically shifts the dynamic, we will make room. And perhaps instead of 2 tables, we'll be getting 3 or 4. We'll see how it goes. But obviously that there's going to be a whole analysis there that has to happen. And we're taking it day by day.
Understood. That's all I had, Your Honor. Thank you.
Okay. Thank you all. We'll, if nothing else, we'll see you on the 6th.
Thank you.
Thank you,
Thank
Judge.
you, Judge.